Hello, this is Roger Guy of Chapter7Attorneys.com. I wanted to talk to you about an issue that sometimes happens to clients after their case has been discharged or wiped out or closed by the bankruptcy court. Sometimes you may come to learn of a claim that somebody had against you long after your bankruptcy case has been closed. And the issue becomes, can the case be reopened in order to add that creditor and have that debt also wiped out? And basically that issue is determined by 11 U.S.C. 1015. And the issue becomes whether the claim actually existed at the time that you filed the original bankruptcy case. There are two tests that really apply here, and that's the conduct test. And under that standard, the issue is whether the act that actually occurred actually happened prior to the time that you filed your bankruptcy case. It's not when the harm is discovered. So for example, let's say, for example, you were called on to represent somebody, in a deed situation and you performed your duties negligently. The issue would be what was the date of that action that you took that conduct, not when 2 years later or 3 years later when they actually discovered it. Under the second test, some courts use what's known as the pre-petition relationship test. And under that test, there has to have been a relationship with both you and that creditor prior to the time that you filed that bankruptcy case. And the issue is that the conduct, that is, that conduct must have also occurred prior to the time that you filed that bankruptcy case. And if so, then of course you could file a motion, reopen the case, and have the debt discharged. And each jurisdiction is different, and so you'd have to consult with a local attorney in your area to know which test applied to you if you found yourself in that situation. I have 11 metro meeting offices around town, and so if you have any bankruptcy questions, feel free to call me or visit us at Chapter7Attorneys.com. The number again is 770-792-1000. Thank you for your time.